Well, as the registrar.
Oh, no.
Oh, as
Shoot.
a deputy, you don't have. No, right. So you have to be endorsed by the party, and you have to get voted in by the town. So when you went to vote.
Yeah.
You voted.
Nope, there he is.
Which is
Dun,
still
dun, dun. I have to-
because it's a non-partisan position. It's required that there's a Democrat and a Republican, and if there was never an independent. But it's not, the work is non-partisan, but then you have, and it is, and that's why I don't get voted for is, I think, wrong. Because it makes it seem like, oh, I'm gonna vote.
What's going on here?
No, I want that. But, and I think that's confusing, it's very confusing, because all you need is one vote. And the other person needs one vote also. You have it. But, and then you are employed by the town.
David, I can't, Delia, I can't get my, oh, here, start video.
Yeah, Meg, can you hear me?
I can. Hi, everybody. Sorry, I was 2
Hi.
minutes late.
Hi, Adam. Hi.
Hello, David.
Let's.
Hello.
Meg, thank you very much. And a big thanks to Adam and Tom for joining us for this conversation tonight. The topic is, as Meg said, the Supreme Court in crisis. The plan is to talk about 4 topics. And the headlines are some major decisions from the Supreme Court term in 2022, some key decisions that will be made this spring by the Supreme Court. The third topic would be the Supreme Court's legitimacy. And as you all probably know, the court's public standing is about as low as it has been in probably since the 1930s. And the fourth topic would be what might happen to the court, if anything, in the future, so that the court's public standing is in fact strengthened and improved. Before we get into the topics, I wanted to just say a word in case some of you, just to remind you a little bit about American history in the court. And one thing would be that the court, almost from its beginning, has been in major national controversy. Thomas Jefferson, the third president, sorely criticized the Supreme Court's decision of Marbury versus Madison because he strongly objected to the idea that the court could exercise any reviewing power over what the executive branch did. You may not remember, but Abe Lincoln ignored a circuit court opinion in ex parte Merriman. He simply let the decision rest in the books, paid no attention to it. And so that was really a case where what Andrew Jackson figuratively said, which was let John Marshall now enforce his decision. That is a case where Lincoln actually did do that, which was to totally ignore a court's decision. The third thing is FDR drafted a speech where he was about to tell the United States Supreme Court that he was not going to comply with the so-called gold standard decisions of 1935. It turned out that they came out the way he wanted them to, and therefore he didn't have to deliver the speech. But the speech is in draft and is in his public files. And lastly, I would just remind you that FDR wanted to pack the court. He wanted to increase the court size from 9 to 15 in response to what he considered to be a whole slew of hostile decisions. So finding the court today in the middle of a crisis is nothing new in American history, although to some extent, I think the current crisis is different than it was in the past. One last word. Some of you probably know from all the newspapers that many people criticize the court or the past recent court for being a radical left-wing court, which was really out of control, and that the current set of justices are required in order to bring some sense and stability back into the law. Well, apart from the substantive decisions themselves, one thing I wanted to bring to your attention is when Richard Nixon ran for president, he ran partially on an agenda, which was he was going to appoint strict constructionists to the court. And since 1969, there have been 20 members appointed to the court, 15 by Republican presidents, 5 by Democrats. and all three chief justices since 1969 have been appointed by Republican presidents. So to some extent, the idea that the court is made up of a bunch of lefty Democrats is simply not consistent with the facts. All right. With those introductory comments, let's turn to the term of 2022. There were lots of obviously controversial decisions: abortion, guns, the administrative decision in West Virginia versus the EPA, and then there's Kennedy coach praying on the 50-yard line in a football game. So, Adam, how do you think about the 2022 term in terms of these controversial issues? Was the court really shaking the ground under our feet, or was the court simply handing down a number of decisions that stirred some controversy but were in line with what the Warren Court did?
I think it was a cataclysmic term. It was the first term, really, where the 3 Trump-appointed justices and the 6-justice Republican appointee majority really took hold of the court. So I've covered the court for 15 years, and for almost all of it, it was a 5-4 court that leaned right, but Justice Kennedy in the middle would often surprise you with major decisions, joining the liberals on the death penalty, abortion, affirmative action, and especially gay rights. And then for a brief period, the Chief Justice was at the center of the court, and he would occasionally surprise you with decisions that leaned left, probably a consequence of his institutional commitment to the prestige, authority, and legitimacy of the court. But when Ruth Bader Ginsburg died in 2020 and was replaced by Justice Amy Coney Barrett, the composition of the court switched. And we not only had a series of cases that all went in one direction in the big cases, and all by essentially 6-3 votes. But you also had the feeling that we've entered the era of an impatient, aggressive, and ambitious court that seems to think it has no time to lose to undo Roe v. Wade, which it may well be the decision. If you ask the American, what decision have you heard of? They might say Bush v. Gore, they might say Citizens United, they might say Marbury, they may well say Brown, but pretty sure among those decisions would be Roe v. Wade. And to basically arrive at this majority, and in the face of repeated reaffirmations of that decision, notably in the Casey decision, and simply to undo it and to steamroll over the Chief Justice, who tried to find a middle ground, but was all by himself on that middle ground, really announced that we're in a different era.
Tom, what do you think?
Yeah, I think it's the personality that seems to me to best exemplify what's going on in this last couple of year period is Justice Alito. And you get the sense reading his prose that he's almost angry or irate, that there's a tone of impatience, pushiness, derision or scorn for anyone who might disagree with him, including the dissenters, to some extent, including the Chief Justice when he tries to moderate it. I think the Dobbs decision is itself a very good exemplification of all this, because as some of you may have paid a lot of attention to this, Mississippi initially said 15 weeks, which is a kind of which instead of 26 or whatever, or viability, and or the Casey decision standard, which was a little vaguer, but that the Supreme Court really reached out and grabbed this case and didn't decide it as initially presented, right, David? They decided it all the way back to the beginning and said that states could ban abortion from the point of essentially conception. And I think you have in that, and in the Alito decision, a sense of a court that's grabbing, I mean, I hate to say it, but it's grabbing power. It's grabbing rights. It's seizing as much territory for a right-wing or reactionary position. It's certainly not a conservative position as it can. And we see it almost everywhere, whether it's a small chiseling decision like on the vaccines and so on, or it's a really strong aggressive decision like the abortion decision or the guns decision, another very aggressive case telling the country that essentially consequences don't matter. And our version of the history of gun control and gun regulation and our reading of the Second Amendment is the one that's going to obtain. And consequences, in a sense, be damned. And it's an aggressive court at this point, the majority on the right. The Kennedy decision is interesting in that way. Kennedy is the football coach out in Washington who began praying quietly and ended up having crowds of his own students and players, and then crowds of other fundamentalists or very Christian people praying with him while on the payroll as a fully paid and fully employed coach. And you get the sense reading the opinions in that case that the majority really wasn't paying a lot of attention to what he was doing, to the very public paid nature of these prayers, and was using evasions and so on. So I think it's an extremely aggressive court.
Yeah. So for folks who don't really remember all the chronology here, in 2017 or in 2016, Obama nominated Merrick Garland to the court. And if you remember, Senator McConnell refused to hold a hearing on the case. And so after the 2016 presidential election, President Trump nominated Gorsuch to the court, and he was approved by a vote of 54-45, which is pretty close given historical voting patterns for nominees to the Senate. The next person that Adam was referring to would be Justice Kavanaugh, and he was put on the court in 2018 and in replace after Kennedy retired, and his vote was 50-48. And then Barrett got on the court, and her approval was by the Senate was 52-48. And so they were all pretty close. And those are the three people that really joined Robertson, Alito, and Thomas in creating a hard block of 6 votes, which are determining where the court is going. I cannot think of another time where the United States Supreme Court has taken away what a previous Supreme Court has said was a fundamental personal right, which is what the Supreme Court did in the Dobbs case by basically saying there was no constitutional right for a woman to decide whether or not to have an abortion or not. Adam, can you think of another case where the court took away?
I think your formulation is careful about a personal individual right. You could say that in the Lochner era, where the court found a right to contract in the Constitution and then walked away from it, some version of this happened.
Good. What about you, Tom? Can you think of a case?
No, I mean, I agree with the Lochner point. To give the devil the due, they're claiming to have found a right. In this case, in the legislature, is ultimately what they're aiming for is to find a right in the fetus, right, David? In other words, they're claiming to say there is a counterbalancing right here, just so we have the arguments out. And clearly that's where the right in American politics and American lawmaking is heading with passion.
Yeah, well, let's step back from the decisions a little bit and look at the methodology or the interpretive methodology that the court uses. Is this court in 2022, is it a textualist court? Is it an originalist court? Or is it a court that's really committed to outcomes and then will use whatever methodology it takes to get 5 votes? So how would you think of it, Adam?
I think, and I think this is the thrust of your question, in many ways, it's an opportunistic court. But in some ways, it's a court that is injecting a kind of fetishization of history into its analysis and doing away with what our court and courts around the world have traditionally done, which is try to find the balance between competing values and try to figure out what the aim of the government is and whether the means to which it's using to achieve that aim are the proper ones. And that's what you do in the First Amendment and elsewhere. What was novel about the guns case was not only the outcome. You might have predicted the outcome, having said in 2008 that you have an individual right to own guns in the home for self-defense. it's not an enormous surprise that this court says you have an individual right to carry a gun outside the home for self-defense. You may agree with that, you may disagree with it, but it follows from the first decision. What was novel about it, though, was that Justice Thomas, in his majority opinion, said the way you analyze whether a given gun control law is constitutional or not is by looking back to the founding era and trying to find the closest analog of a law to the current one. So the Fifth Circuit, the Federal Court of Appeals in New Orleans, recently struck down a federal law that made it a crime for people who have domestic violence orders against them from having guns, saying that violated the Second Amendment. Why? Because they couldn't find an analog in the 1700s for that law. That's really an extraordinary move, and it tells you something about, if not a strict adherence always to these doctrines of originalism and textualism, a real impulse to look to the founding era to control 21st century American life.
David, can I jump in there and say, now, everybody listening, and I know it's David has attracted a big crowd, or Meg has, you've all heard of originalism, the idea that you go back to the original, as it's now said in jargon, public meaning of the words that the framers used in context. I think originalism is a fraud and a fake, and I suspect David and Adam are pretty close to my position in that. Any lawyer is going to look at the text of the Constitution, any citizen would, and start with the text and start with how it was framed. But the originalist arguments now are essentially that this court of on the right grabs at history, and you may not have heard the phrase law office history or judges' chambers history, but they grab the history they like, and they grab the level of generalization or abstraction in a given term, like free speech or the press, and or the regulation of a well-regulated militia. And they insist that this reading of the evidence, if you will, the historical record, is accurate, is permanent, is final. They are telling you what the framers meant. They are inside the original intent. This was originally argued for as a conservative, literally conservative thing that would restrain judges. But what it seems to have done now is a smokescreen, is allow them to just dictate a view of history that they happen to have and that happens to accord with their politics. And we all know that history is not done that way. History is constantly in revision and in challenge, and new ideas, new evidence, new insights, new arguments come up. So this is a really backwards way, if I may say this ironically, of doing history. And it's just not fair to the real historical research and arguments out there.
I would add just one thing about the gun case, which is the Bruen case, which arose here in New York. That was the decision last June of 2022. That was a vote of 6-3. And the reason why I emphasize that is because many people think that Chief Justice Roberts is a quote unquote institutionalist who is trying to some respects balance out the far right conservative or radically conservative justices on the court against something else. But he joined that opinion by Roberts, which is one of the most extreme opinions I've ever read coming out of the United States Supreme Court. Thomas says in that case, in case you haven't ever looked at it, is that contemporary considerations for public safety are not relevant to whether or not a state or the federal government may adopt a gun regulation. The only thing that's relevant is whether or not the regulation that's in dispute is a regulation that has historical legitimacy to it back at the time when the Second Amendment was adopted. If you can't find a historical analog, then the regulation is totally out. And so all public safety concerns that you might have or I might have regarding gun regulations are, from that point, from the point of view of that opinion, just irrelevant. And so a lawyer writing a brief to the court would not presumably make any reference at all to public safety concerns about that.
As in
If
Adam's
I-
example, right?
Go ahead, Adam.
As in the example of the domestic abuse question. I want to add one thing that I just want to underscore, and I hope you and Adam agree with me, or if you don't, the hell with you. And that is, they're doing history in a way that's unfair to the actual available evidence. Many historians can say that there are analogies to be found for the kinds of regulations that New York or other cities, Chicago, Washington, et cetera, have engaged in. And this reactionary side of the court is very loath to admit the persuasive power of evidence to the contrary. They're perfectly willing to ignore it.
Go ahead, Adam.
There's so many things to say, but let me say a couple of them. One, I want to stand up for the Chief Justice just a little bit. You're 95% right, I think, David. But he did join a concurrence in Bruin by Justice Kavanaugh, which tried to limit the sweep of the decision and carved out a number of areas in a number of ways that Kavanaugh said gun control laws might still be sustained. As for history, I do adopt everything Tom says, and I'd make this point, that at the Supreme Court, at least, they have each of them, each justice has 4 Brainiac law clerks, and they can go to the Library of Congress and they can try to do something like actual history. They so far haven't succeeded. But what they're telling the district court judge with a very busy docket, that district court judge is meant to figure out what the framing era status of violent felons was and what counts as a violent felony. And I mean, the whole thing is kind of comic.
David, I'd say one other thing with Adam about the Chief Justice, and that is in the abortion decision. He clearly wanted a compromise. I know it would be antithetical to many of our liberal views about the right to abortion and women's rights, but he clearly was pushing for a European style acceptance of something like 15 weeks and went along, it was a concurrence, but he is something of an institutionalist. I mean, if you had to choose between the Thomases, the Alitos, the Gorsuches, who, with his sort of his specific view, I think Roberts is a better right winger or conservative than the others, more respectable, his opinions have more weight to them and more argument to them.
Yeah. Well, okay. I'm less charitable to the Chief Justice, but I'm happy to have as much charity around the table as we can find. One last thing I would say about originalism is that, and I would reframe a little bit about what Tom and Adam said about it, but to make it, I think, the point really clear, one of the main justifications that the court uses for engaging in this historical inquiry is that the court is going to eliminate judicial discretion in interpreting the Constitution. We're going to get rid of personal preferences, which Earl Warren or Bill Brennan had when they decided the cases, and we're going to get rid of it by inquiring into what the public meaning was of the Constitution back whenever, right? The problem with that, as Tom and Adam has already suggested, is a historical inquiry doesn't get you a single meaning, that the historical evidence is often ambiguous or unclear, or historical traditions are competitive. And so you don't actually eliminate discretion in interpreting the Constitution under originalism. All you do is to create a facade that you are, but in fact, you're exercising a lot of discretion anyway, right? With that, if you, Tom or Adam, if you want to comment what I just said, that would be fine. But otherwise, I'm ready to go on to topic 2.
Okay, go for it.
All right. Well, topic 2 is what's going to happen this spring, and let's start with affirmative action. Adam, I know you've written quite a lot about this. So, what do you think the Supreme Court is going to do on affirmative action in higher education?
The court is going to do away with racial preferences in admissions to colleges and universities, both public and private.
And do away with
a
it.
6-3 vote.
Are they going to overrule Bakke, or are they simply going to say that you can't exercise racial preferences on admissions?
I think they will overrule Bakke and Grutter.
Mhm.
It's possible that all they say, I don't think this is the likely outcome. It's possible that all they say is, although, as those cases recognized, educational diversity is an important value, perhaps a compelling state interest, maybe recognize that for sake of argument, but say that these holistic admissions processes in which colleges and universities taking out of race is one factor among many, but in fact generally give historically disadvantaged minorities a substantial boost, is not a tailored way to achieve that goal.
And I agree, David. I think they're going to get rid of it. I think they're going to leave the colleges and universities, public and private, with really only the questions of poverty and disadvantage as a leverage against exclusions or against a class bias, if you will. In this, they're going to follow. In this, the chief is really going to be very influential. The way to
Yeah,
end
so-
discrimination is to stop discriminating on the basis of race, as he famously said. So, as somebody who was a college administrator, I would say it's the only resort is going to be to put tremendous emphasis on background conditions, kids coming from violent neighborhoods, poor neighborhoods, less privileged high schools. There's only one direction that they're going to really allow, I think, quote unquote, affirmative action or differentiation, not on the basis of academic credentials, but
Well, given your experience, Tom, with college admissions, do you think that that shift in focus will be able to maintain a substantial diversity in college admissions, or will diversity as we now know it in college admissions be greatly harmed by the Supreme Court's, or by the predicted Supreme Court outcome?
well, the lesson from California, where the referendum, got rid of it years ago, is that there's going to be a tremendous dip in the elite universities, public or private, and then there will be, I suspect, because people are morally committed to this, a tremendous effort to do more on the recruitment and on the focus on disadvantage and so on. The point that President Obama made years ago, that my children, his children, shouldn't get affirmative action simply on the basis of their skin color because they come from a very privileged family in financially and obviously in cultural capital and so on, is, I think, going to be the way it's going to work. And if it has been troubling to American politics and moral and political arguments, it's largely on the question of, are our elite universities, public and private, simply recycling an elite of whatever racial background and not reaching out to have more poor kids. I think the New York Times has been pretty aggressive on that. My own Amherst College has been aggressive on trying to get more kids from the lower quartile or the lower quintile. But it's really going to be the only thing that's available, I think.
And Amherst also did away with legacy admissions, did it not?
That's right. Yeah,
Which,
and they
which,
don't do.
which is actually a way to tamp down on privilege replication and incidentally allow other kinds of students to take the place of at least those children who got an unwarranted boost by dint of being an alumnus or the child of a donor or whatever.
Or a board of trustees member who, or somebody of, is given something. The thing I would say about all this here is that there is a long way to go on poverty, disadvantage, difficult backgrounds before American colleges and universities are representative in that class sense. What's going to be hurt here, and I think it's very important, is this thing that you hear in the cliche, someone who looks like me or looks like this person. We're going to see a real dip in that. And I just hope that the private institutions and the politics of America is going to still yield many a Black senator, congressman, many a Black CEO, so that young kids can look up and say, that can be me someday. And the whole racial stigma of American history can be incrementally eroded. But it's not going to be an easy or insignificant change. It's going to be a very big change from little places like Amherst to huge places like the University of, you name it, North Carolina in this case.
Adam, what do you think the vote's going to be in the case? 5-4, 6-3?
6-3. I don't see any liberal vote for ending affirmative action, and the Chief Justice, who, as we've been discussing, is in the current circumstances, and I hesitate to say this in the absolute sense, kind of the moderate on the court on race issues. It has been his lifelong ambition to stamp out government distinctions based on race.
Yeah, that's my view as well, 6-3. Adam, what about this state, independent state legislature doctrine? That may be a phrase that doesn't ring a bell for a lot of people. What's that case about, and how's that going to play itself out in the court?
So the Constitution says in two places that the times, places, and manners of federal elections are set by the states, and moreover by the legislature thereof. So the text of the Constitution focuses on the legislature, and the question in these cases is whether that means we elevate the legislature out of the ordinary functioning of state government lawmaking and take out the governor's veto and take out executive agencies' application of legislative actions, and crucially, take out state court review under state constitutions of legislative activity and let only the legislature speak. So if the legislature says the absentee ballot has to be mailed on Tuesday, and in the pandemic, the state Supreme Court says, well, our state constitution guarantees a right to fair and free elections, we're going to let you mail it on Thursday. That second action, even though on state law, which ordinarily the federal courts have nothing to say about, is no good. And this is a radical transformation of, if accepted, of American law. And one way to know that is that all 50 state Supreme Court Chief Justices filed a brief to say, no, please, let us keep our role as the guardians of state law. And one of them said to me, I interviewed him, the Chief Justice of Texas, a Republican, that this is the most important federalism case maybe ever. So it's a little complicated to explain, but it's tremendously important. I do bring you the news, though, that because the recent judicial election in North Carolina, where this case came from, has flipped the composition of the North Carolina Supreme Court, they've granted rehearing on the underlying case, and that may cause it to go away. That may well be bad news, because this question of the scope of the independent state legislature theory really ought to be decided in an off year, not in the heat of an actual election.
Adam, I think you're making a terrific point there, and I do think they're going to, I mean, it's an invitation for them to just drop it, as you say, with this, the North Carolina Supreme Court is elected, I think, right?
Yes.
And that's what switched. The chief ran for Senate and lost. Very good candidate. I think what's going to, this is a really important principle. I don't know if it's quite the greatest, principle that we've ever had to argue about, as some people have said, but everybody should understand, as Ruth Bader Ginsburg said, that when they say the legislature in the Constitution, in many, many other contexts, the understanding is the power of legislating under a state constitution. And there's a bit of an echo of Chief Justice Rehnquist, for whom Roberts clerked, and Bush v. Gore in all of this, because Rehnquist's position in that whole Florida fight was very eager to jump in and overrule Florida, including Florida Supreme Court. One of the things that may be going on here is that this court can be characterized as a power-grabbing court, as a number of scholars have said, and Adam, I think you've written about that. And there's one of the dangers here isn't just the North Carolina legislature being a bit of a power grabber here in a racially charged and gerrymandered setting, but it's also the court seizing more and more power from its own, when it likes federalism, it proclaims federalism as a principle to knock down the Voting Rights Act. When it sees that it wants to go the other way, it goes the other way and says, well, we'll decide these state issues ultimately. So it's a very complicated sort of set of directions this kind of principle can take us in. And it's very clear some of the right wingers like Gorsuch really would like to say these legislatures should be taken as
But you
Adam, I
make the
think,
excellent and important point that the through line in all this complication is that the court wants to decide everything. It wants more power than Congress. It wants more power than the president. It wants more power than the states.
and before we leave this topic, a moment ago, the Constitution itself does use the word legislature. And so if you were a textualist, right, would not the independent state legislature doctrine have a strong footing in the wording of the Constitution itself?
If I were an originalist, I would ask what was the original public meaning of that term. And the weight of the historical evidence here is very heavily on the side of the founding generation, and state constitutions at the time understood the legislation to be part of the state lawmaking process. Just as the Constitution uses the word Congress, it doesn't mean the US Supreme Court can't review congressional action just because we use the word Congress.
Right. But
Yeah, David, I'd go with that.
hold
Go
on,
ahead.
Tom. Let me make my small point here, which is that there is a distinction here in the outcome you would reach, whether if you were using textualism versus originalism. Because my question to Adam was, if you were a textualist, wouldn't you say legislature?
Yes.
You
No, I
answered by
changed
saying
the
if I
terms
was
of your
an
question
originalist,
because
right. So I just pointed out to people who aren't in the weeds on this, how these two different doctrinal approaches
Yes.
could lead to two different outcomes, right?
But
I'm
David,
sorry.
it is also the case, and this is true in our own language, as we talk to each other and argue, that you really can't have text without context.
Mhm.
And you can't make sense of a French word without knowing a little bit about how the French are using it.
Mhm.
And in Adam's point, I take to be that you can't make sense of the word legislature without having a sense of the context in which
Mhm.
the Constitution of Arizona, let's say, a late joining state, a late formed state, creates a legislature under its own rules. And the danger here is really that thing that we saw rearing its head in all the Giuliani-esque battles in Pennsylvania and Michigan and elsewhere, and that is a really rogue legislature fiddling around. Now, there are lots of federal limits on that, but there's a real danger in taking a word out of context and out of a constitutional governance context and just saying, legislature of uber alles.
Yeah, Adam, go ahead. I cut you off before. What were you
Oh,
going
I'm
to say?
sorry.
Whatever I thought I was going to say, I've forgotten. So let's
Okay,
start now.
all right. So we're moving along here. Let's get to another topic, which is not so much doctrinal as it is the court's legitimacy, right? And so I think recent reports indicate that the public standing of the court is about as low as it has been perhaps since the middle 1930s, and maybe lower now than if it was even then. A lot of things contribute to that, such as the absence of a code of conduct that the justices have to comply with. The Dobbs leak is another. Jody Cantor and Joe Becker's recent report about even another leak involving Justice Alito in a 2014 Supreme Court decision. Well, anyway, so on and so forth. Adam, you're close to the court. You're there on a regular basis. What do you think contributes or has contributed to the downward cycle of the court's reputation?
So let's talk about your premise for a second. It's true that after the Dobbs leak and after Dobbs, the court's approval rating really tested historical lows. It's ticked up a bit since then. And as a demonstration of how polarized we are, the views of Democrats and Republicans about confidence levels in the court is very different. So some of this discussion we're having really needs to be put in the context that the court is a reflection of the polarization we find ourselves in and is not only illegitimate in the eyes of everyone everywhere. I do think that all of that reporting and, just to add one more element to it, the fact that Ginny Thomas, the wife of a Supreme Court justice, should have participated in efforts to overturn a presidential election, and then her husband sat on cases related to that effort, really tells us we're in uncharted territory. But then to go to the second part of your question, I'm not exactly sure what it means for the court to lose legitimacy unless we're in that kind of zone that you were describing at the outset, David, of Jackson and Lincoln simply not obeying the court. And I don't think we're close to that. I think the court, whatever the polling says, when the court speaks, people do what the court says. Justice Breyer used to say, you know, after we decided Bush v. Gore, and I was in dissent, after we decided Bush v. Gore, people didn't go riot in the streets. People say, all right, well, that's what the Supreme Court says. I may not like it, but it's the Supreme Court. And I think we are still in that era and not in the Jackson-Lincoln era.
Mhm. One of the things you just said, Tom, Adam, is let me just reinforce it, because what you said was that the court in some respects is reflecting the, I think, if I, without mischaracterizing you, contemporary political differences between the Republicans and the Democrats. And what I wanted to do was to emphasize for our folks that the nomination of people to the Supreme Court, the approval votes in the Senate, as I already indicated with regard to Kavanaugh, Barrett, and Gorsuch, they're also similar to Alito and Thomas. Alito had the highest votes for confirmation, that was 58 to 42, but Thomas was back down with Barrett at 52 to 48. The reason why I mention that is that if you go back to an earlier time, right, and you look at some of the votes for people like O'Connor, Stevens, Powell, Scalia. I think Scalia was 98 to 0, something
Correct.
like, right? That up until very recently, the votes confirming people to the court were really very lopsided. The one exception, of course, was that Bork was rejected. The other exception is that Rehnquist, when he was approved for the court the first time and then elevated to the chief justiceship, I think he got less than 70 senator votes on his side. But so all of that is simply to suggest that the current Senate confirmation votes for the conservatives on the court really do reflect how the country is divided. And those divisions show up rather starkly in the Supreme Court decisions that we now have.
And you didn't mention, but this is telling, Justice Ketanji Brown Jackson, first African American woman to serve on the court, not a controversial candidate, I wouldn't think. The vote for her was 53-47. 53-47.
Yeah, 53-40. She was in the same group as Kavanaugh and Barrett, just barely making it. Yeah. Tom, did you want to jump in?
I just wanted to say that, I mean, everybody knows this, but the country is polarized. And it's not polarized like Civil War. It's polarized in this whole thing that you see again in to use a catchphrase, national politics, national arguments about religion and abortion and so on seem to dominate even local arguments in small towns and counties and states, certainly. And I think what we're seeing is a willingness, certainly on the part of the Republicans, to do something just very outside the norms, outside the traditions, like treat Merrick Garland as some kind of non-entity that they didn't even have to consider or vote on, when Obama had reached out to make one of the most moderate nominations he could, and not of a kid either. He wasn't nominating somebody who was going to be there for 40 years. There's a willingness now, which we saw in the hooting and hollering at the State of the Union, to just be completely on the cheerleading side of your team against the other team, and come what may, no matter how worthy a candidate Justice Jackson was and is as a justice, to just vote against her because she's on the other side and find some darn excuse to do it.
We have 2 minutes before Meg is going to interrupt us for questions from the audience. So let me ask you a small question, right, which is, what's the future of the court? Given the current controversies, does Congress have the capacity to expand the court? Is that possible? Is it going to cut back on the jurisdiction of the court? Adam, what do you think?
Congress barely has the tools and certainly doesn't have the will, because so closely divided and because of the filibuster and because of constitutional constraints, that I don't see a political response from the political branches to the court's activities.
Before we went on the
Neither do
air-
I, David, just
Yeah,
so you
hold
know.
on, just before we went on the air though, Adam, you made a very interesting point about doing away with certiorari. Why don't you explain that to folks?
So the US Supreme Court decides these days about 60 cases a year. That's because they reached a deal with Congress under which, in almost all circumstances, they get to decide which cases to hear. But Congress can make them hear more cases. Congress could expand the number of I mean, these days, they must hear certain kinds of election cases. You could expand that group of what kinds of cases, or you could tell them to hear every single appeal. That's clearly within Congress's power. And maybe if you kept them busy with trivial cases, they would make less mischief in other ones.
Tom,
But-
you want to say something?
Yeah, I would answer Adam by saying something we haven't mentioned, which is the shadow docket. And that is, they are perfectly capable of deciding decisions without hearing arguments, without really giving us any reasoning. And I think what would happen with Adam's reform is we'd have a kind of, wholesale judging and at that level, and then occasionally a retail case that they really dug into, like the Dobbs abortion case. So
My
I don't
suggestion
see-
is it is more a thought experiment than a serious.
Yeah, I know it is. I know it. I just don't, I think all three of us, because we talked before, are skeptical that with our politics and with our constitution, major changes can be made in this quandary or this problem for America without a huge generational shift in our politics, such that we have something that FDR had, or even LBJ, real majorities in both houses in the White House that want change, and a willingness even to amend the Constitution if that's what it takes.
Or the way the boat has been righted in the past is justices retire, justices die, and you hope the equilibrium, comes to pass again. But this is a very young court by Supreme Court standards.
Yeah, it is. Justice Holmes, when he was stepped down, he was 90. And that was back in 32, right? Meg, I think it's 7:51. We promised you some time for questions. Do you have any questions?
We do have some questions, so I'm going to start with the earliest ones and just read through them. Chris Murphy today once again introduced a bill requiring the court to establish a code of ethics. Do you think that will ever come to pass?
Yeah. Go ahead, Adam. You're very close to the scene. What do you think?
So in 2019, Justice Kagan said in a budget hearing in Congress that the Chief Justice was at work in trying to work out an ethics code that would apply to the justices. 4 years have passed. There was a bunch of reporting today from the Washington Post, CNN, and a little bit from me that says that effort is still underway. The problem is that the Chief Justice is not the chief of his other justices. He's not the boss of them. And to achieve consensus, or probably unanimity, on what the code should say, very hard. Let's assume they do that. How do you enforce it? It's not at all clear that you want a majority of the Supreme Court to tell a minority of the Supreme Court how they should act. It's not clear you should be able to tell Clarence Thomas he must recuse himself, because once you establish that principle based on power, that a bunch of them can tell others of them whether they can sit or not, you could imagine all kinds of strategic behavior. So it's a tough situation, but I think at least on a symbolic level, the justices could at a minimum subject themselves to the code of conduct for US judges, which applies to every federal judge in America except for 9.
Well, I think one of the reasons the court gives about being hesitant about adopting the rule is that they say the United States Supreme Court is different. That if we start having recusals, we may end up with 8 people and not 9 deciding the case, and we'll have a lot of split decisions. I think that's at least one
Right,
of
and they correctly say that every other court can get a substitute. If
Yeah.
one district court judge can't sit, another one will step in. If
Yeah.
one circuit court judge can't sit, another one will step in. As constituted currently, there's nobody to step in
yeah,
at the
yeah,
Supreme Court.
yeah.
All right,
Meg, a
next
second question.
question. In Dobbs, the dissent was jointly written by 3 liberals. In a case like that, is there a lead author?
All 3 of them contributed to it.
Mhm.
The most telling and pungent passages were almost certainly written by Justice Kagan, who's the finest writer on the court.
That's what I was going to say.
Yeah, there occasionally you have joint opinions, and when you have that, no one person really takes credit for being the author, but somebody probably did the draft or did a lot of the writing. But if you find out who did it, it's only because you find out later.
The controlling opinion in Casey, the abortion case, was also jointly written, but you could tell that there was some kind of mystical passages that were written by Justice Kennedy.
Justice Kennedy, absolutely Justice Kennedy. If it was mystical, it had to be Kennedy. Right? Go ahead, Meg.
With
What are your
foggy-
thoughts? What are your thoughts about the leaked opinion of the abortion case before it was announced?
Yeah, what do you think, Tom?
Well, it's, you've read, I mean, they have very sloppy controls. They have a lot of politics. I'm not going to, I mean, I don't think you can put your finger on anybody, although there are little hints hither and yon. But they don't regulate themselves very well. I would go back to your ethics comments. I think they have a lot of, sort of sacred insistence on the sacredness of the court, but they don't seem to have followed up with careful regulation of these kinds of things. And as everybody knows, they didn't really press hard with the justices. They pressed very hard with everybody else in employment in the court, which is a lot of people. But no, I think it looks kind of scandalous. I think cynics would say sooner or later, in a very hotly contested case like this, it was bound to happen. There are too many people who care too much.
Adam, did you hear things that we haven't been reported that you can tell us about?
I think the way you frame that question, the answer ought to be no. But but I think it's possible to pay too much attention to the leak and not enough attention to the decision. The decision remade American life. The leak was a leak. David, you wrote a powerful book about the Pentagon Papers. That was a leak that made a difference in American life. And while who leaked it is a small part of the story, it's the consequences of the actual decision-making there in Vietnam, here about abortion, that we ought to be focusing on.
Yeah.
All right.
Go ahead, Meg.
If the lower court is the trier of fact, in quotes, why can the Supreme Court introduce phony historical facts or analyses as their rationale for sending the case back to the lower court? Why can't the lower court reject the phony historical evidence that was helicoptered in by the Supreme Court and reassert the decision? Can't they just reject the arguments the Supreme Court injected if their historical evidence is just incorrect?
That's it.
Tom?
I'm with David. Laughter.
Well, I think that's a great question. I mean, my guess that, without a particular case and without a Supreme Court opinion defining what it's about to say with regard to the historical evidence, one can only guess a little bit as to what the circumstances are. But here's a guess, which is that when the Supreme Court does, in fact, introduce historical evidence, it's into its opinion, and let's say reverse and remands the decision, is not telling the lower court that the lower court found relevant facts that were introduced as evidence incorrectly. What is telling the court is that this construction of the law, which depends upon the historical analysis, was incorrect because its construction of its interpretation of the history to determine what the law would be was incomplete or erroneous. that's entirely appropriate for the court to do if you are going to engage in an originalist historical analysis. That's what I would say.
The only thing, David, that I would add to that is that, and I'm going over ground we've tilled, but the dogmatism, the insistence, we know what the history is. We read the evidence of history this way and not that way, with no open texture or no sense that it's a little uncertain, is a feature and a characteristic of the right-wing side of this court. And I entirely support your distinction here. The facts of what happened, did a particular person had a gun at a particular time, came under a particular legislation. The court isn't really quarreling with that. They're going at the question how to interpret the law using their law office history on what the framers would have made of it, or the legislators would have made of it.
Adam earlier, by the way, let me just say, Adam earlier said that, a member of the Supreme Court has 4 justices that they can send to the Library of Congress for 3 weeks to do historical work, so that you understand what that can result in. If you ever try to print out the gun decision from last June, right? I think it runs about 120 or 130 pages. And maybe even a little longer. So Adam's point, which is that a single trial judge sitting in Newark or New York or in St. Louis is never going to be able to do anything like that. And so the current burden imposed by originalism on lower courts really makes their job almost impossible to do. Meg, I think it's 8 o'clock. If you want to add one more question, go ahead. Otherwise, I think the curtain's about to fall.
The clock in the library is telling me that it is indeed 8 o'clock, and I think we should wrap it up.
Okay.
Thank you
I
so
want to
much.
thank Adam and Tom very much for all of this, and I want to thank all of you for joining us tonight. It's been a very special pleasure for me to work with Meg and everybody to make tonight's discussion possible. So
Thanks,
thank you.
David.
Thank
Thanks,
you.
Meg. Thanks, Adam.
Thanks, everybody. Have
Thanks,
a
Fiona.
wonderful evening.